Hello everyone. Today our topic is special leave petition. Coming to the introduction, the special leave petition is a remedy available under Article 136 of the Constitution of India, which grants special powers to the Supreme Court of India to grant leave or permission to appeal against any judgment or order in any matter passed or made by any court or tribunal in the territory of India. Coming to the meaning of SLP, special leave petition means that you take a special permission to be heard in appeal against any high court or tribunal verdict. The special leave petition is not an appeal but a petition filed for an appeal. And next overview of SLP. Special leave petition process in the Supreme Court of India. First, the filing of the SLP. The SLP is filed against the judgment or order of a lower court, a tribunal, or any other authority. Coming to the grounds for the filing SLP, a substantial question of law involved in the case. There has a gross miscarriage of the justice. SLP can file in the grounds of the miscarriage of injustice. Next, grant or dismissing leave. The Supreme Court has the discretion to either grant or dismiss the leave. If the leave is granted, the appeal is heard by the Supreme Court. Next, hearing the appeal. If the Supreme Court grant leave, the actual appeal is heard on its merits. It means the Supreme Court may either uphold or modify or reverse the decision of the lower court. And we know that who can file SLP. An SLP can be filed by any person who is aggrieved by a judgment, decree, determination, sentence, or order of any court of tribunal in India. This includes the individuals, companies, and the organizations. Here we know how can file SLP. First one, there is a predefined format of an SLP provided by the Supreme Court in form number 28. And the second one, the party who is willing to file an SLP must mention all the facts clearly to convince the Supreme Court to consider the SLP. And third one, all personal such details such as the name, age, and the address of the parties and the details of the court or tribunal whose order, decree, or judgment has been impugned. And the fourth one, the document of the petition must clearly specify which has been aroused in the case. And the fifth one, it is mandatory for the parties to get the petition signed by the advocate on the record. And the sixth one, the draft of the SLP must be filed with the registry along with 7 copies of it with payment of necessary fee. And next we know when can an SLP be made. An SLP for appeal can only be made where gross injustice has been done to an individual. It means that where the injustice to the individual has done, then SLP can be made. The decision which is being challenged must to be an executive, purely administrative order. And next, a person is not allowed to file a special leave petition against the judgment order passed by the court or tribunal that is involved in settling disputes related to the armed forces. If any disputes relating to the armed forces, that person is not allowed to file the special leave petition. And this is an exception to the special leave petition and is mentioned under clause of the Article 136 of the Indian Constitution. Next, time limit to file SLP. It can be filed against any judgment of High Court within 90 days from the date of judgment, or it can be filed within 60 days against the order of High Court refusing to grant the certificate of fitness for appeal to Supreme Court. Coming to the conclusion, special leave petition holds a prime place in Indian judicial system and has been provided as a residual power in the hands of the Supreme Court of India to be exercised only in cases
when any substantial question of law is involved or gross injustice has been done. It means SLP can file only in cases of where the gross injustice has been done.